Hello. There is no firm date for the emergence of the shire structure in England, centred around the defensible towns or burghs established in the time of Alfred the Great. In the early 10th century, during the reign of Alfred's son Edward the Elder and his grandson Athelstan, they become settled as the unit of local governance and for the administration of justice. There were 39 ancient shires, and their boundaries remained remarkably enduring, in most cases unchanged until the local government reorganisation of 1974, and some of those changes have since been reversed. As earldom became hereditary and the administrative workload increased, sheriffs were appointed, the shire reeve, as the chief official of the Crown in the shire. Each shire was divided into 100 units, notionally a physical measure of 100 hides, a hide being the amount of land deemed necessary to support a family, which might vary between 60 and 120 acres, depending on the quality of the land. In the administrative subdivision of a shire, we are dealing with theoretical hides, the hide as a unit for the assessment of tax. Staffordshire, for example, was divided into 500s. In the Scandinavian-influenced former Danelaw areas of the East Midlands and the North and West Ridings of Yorkshire, where Danish settlement had taken place, the equivalent division was a wapentake, a term deriving from the flourishing of weapons at a gathering to signify agreement with a decision. The term ward was also used in parts of the far north of England. A court for each 100 met every 3 or 4 weeks, attended by all the freemen of the 100, presided over by a reeve, a bailiff of the sheriff. Numbers attending necessitated meeting in the open air, typically on neutral territory, away from any settlement, at a significant landscape feature such as a high point where perhaps a beacon could be lit to guide travellers, or at a crossroads or by a ford. Although their names provide clues, many of these meeting places have never been located. Among the Staffordshire hundreds, Offlow met at Offers Low, a tumulus now ploughed out, about 3 miles south of Lichfield, close to the junction of the major Roman highways of Watling Street and Ricknield Street. Pyre Hill hundred met at the eponymous hill, 2 miles south of Stone. As well as administering justice, the 100 Court was responsible for levying taxes. Profits of the court were generally apportioned 2/3 to the king and 1/3 to the earl. Decisions made at the 100 Court could be appealed to the Shire Court, the sheriff's Tourn, which visited each 100 twice a year. Landowners held their own moot courts to deal with minor infringements on their property. It was the custom in the areas of Danish settlement to appoint 12 men to hear cases. King Athelred's Law Code, also known as the Wantage Code, issued at Wantage in Oxfordshire in 997, provided for 12 thanes to be sworn in to assist the reeve in deciding cases at the 100 Court. Something similar is contained in the laws of his father King Edgar, and it's highly likely this was already the customary practice. Whether or not we are seeing the origin of a jury of 12 good men and true is debatable. While a case can be made for crediting this development to Anglo-Saxon England, some historians claim the jury system began with the Franks and was introduced to England by the Normans. Others date its formal introduction from the 1166 Assize of Clarendon. From 1285 until the 17th century, eligibility to serve on a jury was linked to property holding. Maintaining the king's peace in medieval England was a communal responsibility. Ensuring offenders were brought to justice was enshrined in a system known as frithbor, meaning peace pledge. It may well have been this concept that later developed as frank pledge, in which, with the exception of knights and clerks, every male, aged between 12 and 60, was required to be a member of a tithing. It might vary according to circumstances, but typically a tithing was a group of 10 men under a leader, a chief pledge or tithing man. Each member swore an oath to uphold the law, stand security for each other, and be responsible for bringing any member accused of an offence against the King's peace to face justice. Failure to do so incurred a fine. The equivalent for living members of a manorial household was a similar grouping known as mainpast, under the head of the household. It was the duty of every citizen subject to a crime or witnessing a criminal act to raise the hue and cry, and for those within earshot to respond, pursue and arrest the suspect. Again, failure to do so was punishable by a fine. The system of hue and cry was codified by the Statute of Winchester in 1285, along with that of watch and ward, which developed in towns in the 13th century, requiring watchmen to patrol the streets at night and to detain strangers and wrongdoers, and a ward to operate during the hours of daylight. County began to replace shire as an official term after the Norman conquest, but shire remained in common use and in county names. The hundred as an administrative division disappeared with a very few exceptions in the 19th century. Next time, the role of the coroner, a counterbalance to the power of the county sheriff. If you've enjoyed this video, hit the like and subscribe buttons and click on the notification bell to be informed when the next video is available, or you can subscribe by clicking on the rose window over my shoulder.